Partnerships for the Illinois Bar. All right, so our first rule of partnership is that a partnership is created when two or more persons voluntarily carry on a business for profit as co-owners. Two or more persons voluntarily carry on a business for profit as co-owners. Okay, so if a partnership is created, remember the partnership is the default business structure unless the partnership elects otherwise. So what do we need to create a partnership? Two or more persons voluntarily carry on a business for profit. A general partnership is created when two or more persons voluntarily carry on a business for profit as co-owners. All right, so a couple things that create a presumption of partnership. The actions of parties can form a partnership even if the parties didn't intend to form a partnership. So remember, since a partnership is the default, unless the people elected a different structure, some things that will make the court presume a partnership include sharing of profits and losses and the right to manage and control the business. These are our two big ones: sharing of profits and losses and the right to manage and control the business. Okay, so what are our two big ones? Sharing of profits and losses and the right to management and control of the business. All right, so the other thing, of course, is that partnerships have a capital account. So if you have a capital account, probably you're a partnership. If they represent to third parties that they are a partnership, but really our two big ones are the sharing profits and losses and right to manage or control. All right, so under the Uniform Partnership Act, there is no partnership agreement required. So, however, if the business contemplated by a partnership agreement is not for a fixed term, in other words, it's at will, there's no writing requirement. So the statute of frauds doesn't apply if the partnership is at will and it is just it just makes it a general partnership. It doesn't have a fixed term, it's at will. All right, so conversely, if a partnership exists for term and by its terms can't be completed within 1 year, then we have a need for a writing to comply with the statute of frauds. All right, so by default, partnerships are what? At will. Do we need a writing for that? No, we don't. What's the duration of an at-will partnership? Until somebody disassociates or dissolves the partnership. And what are our two big factors when we're looking at whether someone who has inadvertently created a partnership? Sharing of profits and losses and right to management or control. Okay, so that's all we need to really know about formation of a partnership. Let's talk about status and rights of general partners. Remember, general partners have joint and several liability and single taxation. So it's a terrible business structure, but generally, unless the partners, here's their status and rights, they have the right to be personally sued by everyone. In other ways, here are their status and rights. So profits and losses. Losses follow profits. If the partnership designates nothing, it's assumed that we're going to have a 50-50 split of profits and losses. Of course, a partnership agreement can modify this. So distributions, if that's allowed for in the partnership agreement, distributions can be made. So partners have equal rights in profits and losses unless, that's right, the partnership agreement specifies otherwise. They have equal rights to management and control unless the partnership agreement states otherwise. And that includes decisions in the ordinary course of, that's right, decisions in the ordinary course of business. So sharing in profits and losses, equal rights to management and control, decisions in the ordinary course of business. And let's talk about transfer of their ownership interest. So A partnership agreement, partners are closely held businesses. So can you transfer your interest to a non-partner? Yes, but you can't. You can transfer your economic rights, such as the right to be paid under a contract, but you can't transfer your governance rights. So under management and control, we have this subcategory. All partners are equally um, can equally participate in decisions made in the ordinary course of business. If we have more than two partners, it's going to come down to a majority. But then if one partner wants to transfer their ownership interest, they can't transfer away those management rights. They can't transfer those governance rights. They can transfer their economic rights, their rights to get paid. Okay, so let's talk about partnership property. The partners can use or possess property that belongs to the partnership on behalf of the partnership. What does this mean? Partners can use or possess partnership property on behalf of the partnership. All right, so this could be very easy to conceptualize in terms of computers. You're going to use that computer to conduct partnership business. You're going to use that car to conduct partnership business. Partners can use or possess partnership property on behalf of the partnership, not for their personal use. Okay, so how then do we differentiate between a partner's individual property and stuff that belongs to the partnership? Well, pretty easy. Okay, what assets were used to purchase it? Partnership assets, partnership property. Title. If the property is titled in the name of the partnership, that's another huge clue. Okay, so can partners give their own property to the partnership? Sure, they can. Can they rent their property to the partnership? Yes, absolutely. Can they loan money to the partnership? Absolutely. Okay, so let's look at our status and rights. Profits and losses, 50-50 split. Losses follow profits unless the partnership agreement says otherwise. Equal rights to management and control, decisions in the ordinary course of business, that's right. Transfer of the ownership interest, but only the economic rights, that's right, not your management rights. And how do we decide whether something's partnership property? We're going to look at the source of funds, and we're going to look at the title. And can a partner use partnership property for personal use? No, they can use it for partnership use. And a partner can, of course, loan or give partnership property to the partnership. That can become part of that partner's capital account. Okay, are partners automatically entitled to compensation? No, they're not. They're not entitled to compensation for services rendered to the partnership. They can get reasonable compensation for services that they render in winding up, but under normal circumstances, we're talking about profits, losses, and distributions, not compensation such as salary. That could be part of the partnership, but it's not a requirement. The partner is not entitled to compensation for their services rendered. Now, does a partner have the same right to information as, say, a stockholder would? Absolutely. The partners are entitled to be informed about the partnership business. Even if one partner says that consent is required, consent is not required. All general partners are entitled to information about the business, every kind of information. All right, so let's talk about those wonderful fiduciary duties of the partnership. So of course we have our first duty, which is the duty of loyalty. That's right. So duty of loyalty, that's our duty to put the partnership interests ahead of one's own at all times. And so what's a violation of that? Appropriating a partnership opportunity, self-dealing, conflicts of interest, competing with the partnership until disassociation is complete. So appropriation of, that's right, a partnership opportunity, self-dealing, conflicts of interest, and competing with the partnership until what happens? Disassociation. When you disassociate from the partnership, then you can compete. But the duty of loyalty is going to prevent our self-dealing, appropriating partnership, that's right, opportunities. It's going to prevent conflicts of interest and competition with the partnership until what happens? Disassociation. All right, the duty of care, that's to refrain from grossly negligent conduct. Grossly negligent conduct or knowing violations of law. Okay, duty of care is refrain from grossly negligent conduct and knowing violations of law. Refrain from negligent conduct and knowing violations of law. That's our duty of care. Don't make knowing violations of law. Don't be grossly negligent or reckless. Then you are cool on your duty of care. The duty to account. So a partnership has to keep adequate books and records. And do the partners, do you think they have the right to inspect those books and records? Yes, of course they do. Does the partnership have a duty to furnish that information to the partners? Yes. So the partner owes the partnership the duties of loyalty, duty of care. The partnership owes the partner a duty to account, a duty to render information. All right, so let's talk about partnership liability to third parties. Well, of course, we have joint and several liability in a partnership. So the typical agency rules apply here. So a partner can have express or implied authority or apparent authority by holding out to a third party that they have authority, and that will bind the partnership. A general partner is, of course, jointly and severally liable for all of the stuff, all the other things that their partners do. But what about a newly admitted partner? A newly admitted partner is not personally liable for anything that happened before they were a partner. Let me repeat. A newly admitted partner is not liable for debts or obligations incurred prior to joining the partnership. That just makes sense. You join a partnership, you're not automatically liable for everything the partnership did before you came along. A disassociated partner remains liable for obligations before they disassociate. So in other words, you can't just disassociate and get rid of all your obligations. Those obligations continue until they are wound up. Okay, so general partner, jointly and severally liable. Newly admitted partner, what do we need? They're not personally liable for anything incurred prior to joining the partnership. Disassociated partner remains liable for obligations incurred before the disassociation. Okay, so what about a purported partner? Well, we get back to our agency rules here. A purported partner, someone who holds themselves out as being a partner, has the same liability as a general partner. You hold yourself out as a partner in a business and you're not, guess what? You are liable. You are liable if a third party reasonably relied on that representation. So a purported partner is going to have the same liabilities as a general partner if they hold themselves out as being a partner and a third party reasonably relied on that assertion. Okay, so let's talk about disassociation and dissolution. So disassociation, remember under the revised Uniform Partnership Act, disassociation doesn't automatically terminate the partnership, whereas under the UPA, it does. So how does one dissociate from a partnership? Okay, so by providing notice to the partnership, which doesn't have to be in writing, verbal notice is fine. So you basically give notice of your express will to withdraw from the partnership. Email, text, fax, verbal, no matter what. It's no writing is requirement. No writing is required. Okay, so the partnership can also just simply terminate because it's a partnership for term. So if that particular event occurs, that would disassociate the partner. If the partner becomes a debtor in bankruptcy, that's going to cause disassociation. One partner files bankruptcy, boom, disassociation. Okay, so what then is wrongful disassociation? So there's rightful disassociation. I'm going to disassociate from this partnership. I'm giving you notice. Then that partner is going to be liable for obligation incurred before disassociation, and they retain their fiduciary duties, and they retain some management and control over winding up of those obligations. Wrongful disassociation occurs if someone leaves before a partnership for term expires, or if they go against the partnership agreement. So if there's a partnership agreement and someone goes against it, or if it's a partnership for term and someone leaves before term is up, then that's wrongful disassociation. As of course, if they do something really horrible and stupid, then they can be expelled pursuant to the partnership agreement. Okay, so remember, partnership agreements can vary all of these things, but in general, wrongful disassociation occurs when someone disassociates from the partnership in an action that contravenes the partnership agreement. Okay, or before term expires. Wrongful disassociation is actually a breach of contract. So that's important to remember. So if a partner wrongfully disassociates from a partnership, that gives an action for breach of contract. Okay, so one other very important thing, liability. Okay, take a wild guess. Do you think the partner is liable for damages if they withdraw from the partnership wrongfully? You bet they are. Remember, disassociation is a breach of contract. So if a partner wrongfully disassociates, that partner may be liable for damages for the unauthorized withdrawal. So the effect on of disassociation could trigger a dissolution of the partnership if it's just a two-person partnership, or a continuation of the partnership with a mandatory buyout. Okay, so the disassociating partner is entitled to a buyout of their interest. If the partnership is at will and there are two partners, that'll trigger dissolution. If we have a large number of partners, dissolution can be express vote of at least half of those partners. And if there is a partnership for term, it'll be dissolved when the term expires. So partnership at will, dissolved if it's just two people, one quits, express vote of the partnership, or when the term expires. Okay, what is a partner's mandatory buyout? Well, it's going to be the amount that would be distributed to the partner if those assets were sold on that day, their liquidation value. And what if the partner disassociates wrongfully? Do they still get a buyout price? Yes, they do. They get their buyout price minus the damages caused by wrongful disassociation. So you wrongfully disassociate, you're still entitled to a buyout, but it's reduced by the damages you caused. Wrongful disassociation, breach of contract, damages, anything that you put into the partnership, you're going to get back minus those damages. Okay, once a partner disassociates, they cannot continue to participate in management and control of the business. That just makes sense. However, they can participate in winding up of the partnership business. So if they rightfully disassociated, they can participate in winding up, but they lose their management rights. And the dissociated partner does retain the authority to bind, but that is going to end when the partnership is dissolved. All right, so we talked about dissociation, rightful and wrongful. Let's talk about dissolution. All right, so dissolution, okay, easy. If it's a partnership for term, it dissolves when the term expires. If the partnership is at will, we need a vote, or if it's just two people, one of them withdraws by express will. If the parties agree to do business after the term, let's say we have a partnership for term and one of the partners agrees to do business, there's a presumption that the partnership still exists. Okay, so a partnership can also be judicially dissolved. So for example, if the partnership's economic purpose is frustrated, it's not profitable anymore, it's not practicable to carry on the partnership business. So wrongful conduct by a partner means it's not practicable to carry on the partnership business. Or 90 days pass during which the partnership doesn't have at least two partners. This is similar to an LLC, isn't it? 90 days with no members, dissolved, judicial dissolution. Okay. So winding up, after a partnership dissolves, it continues solely for the purpose of winding up the business. The partner, if their disassociation is rightful, they have the authority to perform acts that are necessary and appropriate to the winding up. If the disassociation is rightful, the partnership continues for the purpose of winding up, and the partners have the authority to perform acts necessary or appropriate to the winding up. Wrongful disassociation? No. Okay. And the partnership terminates when? That's right, when all of its business is wound up. Okay, so let's talk very briefly about limited partnerships and how that works. So a limited partnership is one general partner who has joint and several liability, and limited partners, an unlimited number of limited partners who don't have personal liability. Their liability is limited to their capital investment. Okay, so a general partner, the general partners have joint and several liability and all management responsibilities. The limited partners, no management, no liability, except for their capital investment. They could lose that. Okay, so general partners, so limited partners, actually, let's talk about disassociation, dissolution. That's pretty similar to partnership, but let's talk about limited liability partnerships and conversion of partnerships. So a limited liability partnership is a form of general partnership that is created, unlike a general partnership, by filing a registration statement with the state and paying a fee. So a limited liability partnership, or an LLP, that needs to be a filing with the state. It's similar to a general partnership. Now, let's talk about when we want to convert, because a general partnership, as we know, sucks as a business structure. So if a general partnership wants to convert to a limited liability partnership, they can do it by vote. If that's not specified in the partnership agreement, the vote has to be unanimous. So general partnership to LLP, limited liability partnerships, unanimous vote. And guess what? General partnership to limited partnership, unanimous vote. You want to convert your general partnership to a limited liability partnership or a limited partnership, unanimous vote. Okay, so how about a general partner? Okay, so the general partner is going to be liable for the partnership obligations until the date of conversion. anything up to the date of conversion. So remember, our general partner has the joint and several liability, and they're going to be liable for anything up to the date of conversion. All right, and that is the very basics of partnership. I hope that was fun. Enjoy.